LD 1786 is called an act to maintain consistency among Maine's non-discrimination statutes. And in a nutshell, what this bill does is builds on the work that the Judiciary Committee did in the first session of the legislature. The Maine Human Rights Act had a lot of inconsistent language, and so we went through that act and made sure that there was consistent language used to describe the types of discrimination that were prohibited under that act. That's Maine's major non-discrimination statute, and most issues related to discrimination go through that act. But if you look in our statutes as a whole, you see that there's lots of other non-discrimination statutes, found in different pieces of the law, like in the insurance code and in regulations about entitlement for professional licensing. And so what this bill does is it goes through everything outside of the Human Rights Act and imposes the same standard language, except where it's not appropriate. So a great example would be that the Maine Civil Service Code of Fair Practices and Affirmative Action says that complaints of discrimination based on race, color, religious creed, national origin, age, physical handicap, or mental handicap should be made to the Maine Human Rights Commission. But then when you look at the status of the Maine Human Rights Act now, you see that some of the words that are used in the Civil Service Code are actually obsolete. So we don't refer to religious creed now, we just refer to religion. And we don't use the word handicap, we use disability. And so one of the areas in which LD 1786 made changes was in that Civil Service Code, getting rid of the word religious creed and inserting religion, and then changing handicap to disability. And why it matters is that when you've got these anti-discrimination provisions, employees, for example, refer to them in understanding their workplace rights. Employers refer to them in determining, for example, whether they have to accommodate a request by an employee. And courts use them too, because courts have to decide cases. And if we're using language that's a little bit different in each of our anti-discrimination statutes, it just causes confusion for everyone. For example, the law on whether, when, and how you would accommodate an employee's request for accommodation related to a religious practice, that is very clearly set out in case law. But if you change religion to religious creed, it becomes a little bit less standardized. Similarly, and a different reason, is that there are some words that we now find to be really disparaging, like using handicap as opposed to disability. And so we want to make sure that all of our laws are using updated, respectful language that is consistent with the way the courts are interpreting other statutes that are granting the same legal protections. The problem that 1786 is trying to solve is that Maine has adopted various non-discrimination provisions in our entire body of statutory law over many years. And that piecemeal adoption and amendment of laws has led to a lot of inconsistency. So the problem that we're trying to solve is that we're using a lot of different words to refer to the same thing. And why the legislation matters is that by changing all of that inconsistent language to a consistent set of terms, we, first of all, make sure that we're using the most current and respectful language that we can regarding people who are in protected classes. And secondly, it gives everybody who relies on these laws, whether it's somebody protected by them, an employer who's been asked to accommodate religious practice, or a court that's trying to interpret the law. If we're using the same language, then we give much better guidance to all of those people who are impacted by these laws. So LD 1786 has recently been reported out of committee. It will come to the floor of the Senate and the House likely by the end of February, if not then in early March. It came out with a divided report, which means that some committee members did not support the policy encompassed in the bill. And so it really does need support from the public. So if you are persuaded that Maine should have consistent language among all of the anti-discrimination provisions in our statutes, please reach out to your state senator, your state representative, and speak to them about the bill. Make sure they understand the importance of LD 1786 and urge them to support it when it comes to the floor of the Senate and House for votes. At the public hearing and work sessions on 1786, something happened that I think represents what's so wonderful about lawmaking in Maine and the way our legislature works. Advocates from the insurance industry and from other areas came forward and said, you know, I like the concept of how the bill is going, but it's going to have these unintended consequences. For example, the amendments that were originally proposed within the Maine Insurance Code would have actually potentially increased insurance rates for some people. There would have also been an impact on housing law, particularly senior living housing. And so those advocates contributed a little bit of research and some additional language and really helped shape the bill so that it achieved all of the benefit that everybody agreed it should achieve, but didn't have any unintended negative consequences. And I point that out because I think what's unique about being a legislator in Maine is that input from the public and input from people who are directly affected by the bills comes forward, and we can really listen to it and use that information to pass the best, most beneficial laws that we can for Maine people.